I am Nirupam. I'm from the Bharat Innovates team, and this is a session in the series of sessions to prepare you before leaving for Nice. Before we begin today's session, I would like to acknowledge and introduce our partner, IvyCap Ventures, for bringing this series to you all. As you all would know, IvyCap Ventures, founded in 2011, is one of the leading venture capital firms in India, leveraging IIT and IIM alumni network. It has offices in India, US, and Singapore, managing assets of over 650 million US dollars with 65 plus companies in its portfolio. We are joined today by Ananya from IvyCap. She looks at ecosystem strategy and initiatives and is helping us in putting this series together. With that, I would like to invite Ananya to take over and introduce today's speaker. Over to you, Ananya.
Thank you so much, Nirupam, for this quick introduction. Hello, everyone. Good evening, good morning, good afternoon. So happy to see you all back again today after our last session. And, it's a great privilege and pleasure to have meet you all today and to also have our mentor Cyril take the session. So before going to the session, I just want to set a quick expectation. The session is going to focus on a very, very key aspect that you have to be prepared before you are traveling to France, which is on the legal compliance and operational considerations before you are engaging with the European market. So we are going to talk about, IP consideration, contracts, regulatory frameworks, how to structure for the cross-border business engagements. We will also speak about key legal and regulatory expectations in Europe, awareness around the contract and IP framework, operational preparedness, etc. And today we have a very, very seasoned expert who himself is in Paris, in France. There is no one better than him to do this session today, and I'm so privileged to welcome and thank him for taking his time to be with us today. So Cyril, he is a CEO and founder of CB Consulting and Management with 22 years as an in-house tax director. So through this CB Consulting and Management, he has worked with a lot of CEOs and CFOs of growth stage, mid-size, early stage companies across the countries, across different countries across the world. So he will be helping you to go through all the legal compliance and things before you're traveling. So I would like to welcome Cyril for the session. And as I mentioned last time also, this will be very, very interactive session. We would want you all to ask as many questions as possible so that you prepare yourself before you travel there. So over to you, Cyril. Once again, welcome to you.
Yeah, thank you. Thank you, Ananya, for the introductions. Thank you all. Good morning, good afternoon, or good evening. Don't know where you are all based. I'm talking to you right now from Paris, France, and I wish you a very good trip to come back to go to Nice during the next couple of days, and I'm sure it will be an amazing session for all of you. So as Ananya explained, I'm got more than 22 years of experience, focusing mainly on direct, indirect taxation, also including legal stuff, contractual review. During the last 6 years, I also focus on e-commerce stuff, so I'm quite, let's say, up to date with the latest regulation about US, about also EU and China. So again, if you have any specific question about e-commerce, do not hesitate to, let's say, list them all, and we will get a specific dedicated Q&A session at the end. Let's start. So the interest of this session today for me is to drive you through the main pillars of what you need to know before going global within Europe, and especially with focus on France. So it should be 5 pillars we will discuss today. The first one should be about the company formation, which is the start of your introductions of your, let's say, activities within Europe. And this introduction is really important because the creation of your legal structures will determine many things. It will also influence on a positive or negative way the VC approach, the funding approach. So for your fundraising, you need to know that some certain legal entities structures are better than others. I will go through which are the main ones to look at. After, we will check the fundraising structure and instruments that we got in France or also in Europe. I will explain you what's the main incentive or and how it works. We'll then go through the EU and French tax architectures, including tax audits. It will be a lot of technical things and technical, let's say, specificity, but it's really important to have an overview of each of them. Why? Because in fact, it will also determine your, let's say, potential rentability of your structure in Europe and your project. And also it has for sure, as you know, and if you could all understand, a real impact on your fundraising, because if you take the right structures and the right French or European tax architectures, you will for sure avoid a huge payment, and you will avoid some doubling sometime in terms of payments of taxation. Then we'll move to one of the key points. It's your registration of your intellectual properties. Your intellectual property for most of you will be your key assets of your business. Then it's really important, at least from the beginning, to register it properly within France, within Europe, or within other markets. And then we'll get to the last but not least dividend part and withholding tax, which will also explain you how the French tax treaty or the sometimes other countries, European countries, treaty with India, which make a real impact on the withholding tax and all of the collateral tax. And at the end, as Ananya let you know, we will have a dedicated Q&A sessions, and you can raise all your questions you may have based on the information I will share with you in a minute, or based on all other questions. Again, I will try to do my best to answer all your questions. If some questions are too technical to be answered within few minutes online, please feel free also to share the question with me. You will get all my detail at the end of the slide deck, and I'm quite sure that Ananya can share with all of you the slide decks and everything after the presentation. So let's start. Company formations. Let's focus first on two countries. Why only two first? You will just see within a minute why France and Netherlands are quite working well together and also are the most common, let's say, structuration countries for fundraising. I will give you a short overview of what is existing right now in Europe. So you will get this table, which gives you the main interesting things. So for France, the most interesting one is what we call the SAS, which is in fact limited companies. And these limited companies will work with minimum capital of €1. For sure, €1, it's really the minimum one. In reality, most of the company will start with between 2 to 10k euros as social capitals, because €1 it's let's say minimum legal one, but no one will really use this one to create the company. Limited liabilities, this is really yes for sure, and the specificity is that it's for tech, startup, and AI ecosystems. Got also the what we call SARL, AURL in France, but it's more for SME and sole trader. I will recommend those one only if you do, for example, e-commerce, or if you want to only run your business alone without a real normally needs of VCs. In the Netherlands, you will get the BV, what we call Bestellen Vennootschap, which is in fact the reality, quite similar of SAS in France. Minimum capital, it's only 1 cent, which is very, very low, as you know, but again, it's only a minimum, and in reality, you will at least put few euros as share capitals. You will see after a few minutes that the Netherlands side, it's more focusing about holding on IP and royalties. So you will see the combination of the two structures, which could make sense, and that we would get the best of both worlds. In Germany, you got the GmbH, which is in fact the equivalent of the SAS in France. The minimum capital is quite a little bit higher. It's 25 kilo euros. It's also limited, and it's VC ready, but Germany, it's mainly used for HW, robotics, and engineering. it's not really used for tech and startups, and you would see that German regulation is quite complex versus French or Dutch ones, so we will not really get within the detail of the German one. A very, let's say, last in the list coming countries is Estonia. Estonia is coming in because they got a specific e-residency regime for digital and remote operations, and Estonia has a really specific, very, very low corporate income tax rate, and that's why many people start their business there. Now, from a VC-ready perspective, it is not that Estonia, it's quite, let's say, I note it as partial, but most in reality it could be complex, and I will not recommend this one. And we'll get on top after you got maybe a first positive expansion within Europe. So you raise your Series A, it would be good. Now you are to your Series B and Series B plus. You can go to the SEs, Societas European. In fact, in reality, so this one you will see that the social capital, it's 120,000 euros. So it's more a huge capital to raise. But in the meantime, this type of society is a sort of super European SAS or liability companies. This one is clearly for the next stage only, not for the beginning. Let's try to compare the two one I mentioned, France SAS versus Netherlands BV. So minimum capital, as you see, it's clearly almost the same, but it's, let's say, a sort of tie. There is no real winner. The third one, in reality, you need to know that it's more between, let's say, 2 to 5 or up to 5 to 10K maximum euros in terms of capitals. So corporate income tax rate, 25%, 19% in Dutch BV, but it could be a 15% at the first 42.5K euro in France. It could be after 25.8 after your first 200 kilo euros in Dutch BV. So you will say BV it's better up to 200 kilo euros of revenue after it's quite a tie game. IP innovation box, so what we call CIR in France, is a corporate, in fact, is a tax research credit. We will also, I will give you many more details about it because it will concern many of you, I assume. There is no real IP box. It's still some regulations still planned, but nothing has been yet voted in France. In the Netherlands, there is the innovation box, and the innovation box, it's a 9% effective rate on all your IP income. So IP income means that you register your IP and you get some IP royalties. So again, the winner here, it's BV because there is stronger IP regime. Participation exemptions. So in fact, if you have more than 10% held for more than 2 years in France, you will be exempt on 95% of your participation gain. In BV, it's 100% exemptions, and the minimum it's only 5%. So you will see that there is clearly a better holding regime in the Netherlands versus France there. WHT means withholding tax. So that's something we withhold when you pay dividends. So when your company is paying dividends to the shareholders, you will just keep a certain part of it. So it's 20% for domestic dividends in France, and it's 10% with the Indian tax treaties between France and India. In Netherlands, it's 15% domestics, and you will get, in fact, 10% with the treaties. So with application on both cases of the treaties, it could be the same. Lower regime, it's better in Netherlands versus France. And the tax credits, that's the tax share, so the SEER, what we called before. There is clearly a stronger approach in France. Why? Because in fact, it's a tax credit, but it could be a cash refund. What does it mean? You start your activity in France, you don't get a revenue to be taxed at the beginning, you only have some charge. So you get a negative, for sure, revenue. You get also a negative EBITDA. And at the end, you will just get a tax credit, which could be reimbursed by the tax authorities by submitting a specific request online. Regarding the VC ecosystem, as I explained before, Paris is one of the top for EU AI and deep tech hub. Amsterdam, it's more linked to finance, fintechs, phones, and let's say international companies. So clearly, there is no real winner or loser here. It's more a dependency based on which sector is your company belonging to or not. Employee incentive, what we call BSPCE, I will also give you some insight about this regime in France. It's a specific regime for companies just created and for employees of those companies. There is no equivalent regime in the Netherlands, so here a SaaS company is unique advantage. I don't know if there is any echo. Yep. Is it better? Yeah. Thank you. Yeah. So treaty networks, France has more than 130 country tax treaty with them to avoid, let's say, doublons and to also apply specific withholding regime. Netherlands have almost 100 tax treaties, so it's quite, France is the winner, but again, it will depend where you are. For Indian tax treaty, Netherlands and France have one, so again, I think it's quite equivalent. Substance requirements, that's something really important. We will deep dive because it's clearly oblige you to get some what we call local domestic presence within the country you will select. You will see there in detail after, but what you need to know right now is that the BV it's more flexible versus the French one. And the typical use case, it's mainly an operating company to be lodged in France, like a seed Series A, and you will have to put a holdco or let's say your holding companies for IP and exits in the Netherlands. Why? Because in fact we'll see in a minute that they both work together. Just try to give you some updates and some insight about how it works with the French SAS. So corporate governance. You need to know that when you create an SAS in France, you need to have a board or president of the structures. That's a domestic person based in France, which will be appointed as president of your structures. And then, in fact, this person will represent your company within the French authority and also externally to our other potential customers or to VC funds or anyone. The shareholder quorum is set freely, so you can decide who will, let's say, held what and how it will work in terms of decisions. There is no mandatory supervisory board. There is clearly a possibility to create one, but there is no need of it based on the legal legislation in France. And there is a different multiple share classes, so you have ordinary, preferred shares. As I said, capital on share very briefly, so €1 minimum, practically at least 1,000 or more, pretty customizable liquidity, so you can do what you want with this. So you will clearly you can put some capitals in, let's say, in liquidity, or you can also put some capitals in know-how. You have many different ways to create it. There is some specific shares that you can give to employees, and there is also other things we will just discuss later on. Registration is done online via what we call guichetdesentreprise.fr, which is a specific website. It takes almost between 5 to 10 business days to create it, and the cost vary between 400 to 200 euros, only the administration fees. Now, if you want for sure to use someone who knows how to register it, you can get it for around, let's say, 500 to 1,000 euros minimum. The VAT number should be received within 1 to 3 weeks after filing everything online and getting your registration numbers. Tax residency and peer risk. So your French corporate taxation if management and control in France. What does it mean in practice? As I said, you need to have a French president, you need to have someone based in France working only for the French company. If you are thinking of getting someone like acting as your president based in India, for example, it should be considered as a real PE risk, and we will also explain what it is. So the critical non-resident director, as I said, it's a PE risk, and the use of French resident, that's something which is preferred. What are unique French advantage? As briefly explained before, the research tax credit, the CIR, it's a 30% R&D tax credit, cash refundable, which is really important. You have also some social charges exemptions for researcher people, and we got also the BSPCE, which are the unique employee warrants, and in fact it gives you a possibility to give to the employees at the creation of the company some share which will clearly, or some warrants, sorry, which will clearly have an incentive in terms of taxations. We have also Station F, which is a Paris Unis ecosystem. I already met the guys there working there, and it's clearly a very nice ecosystem. If you are interested, I can also give you the link to this ecosystem. Key compliance, you need also to get some annual accounting file at the graph. Graph is the equivalent of the sort of centralized registration companies database. So you need to publish your result, your revenue, and many mandatory informations. You may need some official accountancy firms to review and audit your account if you are above 2 million revenue or 20% of staff. GDPR compliance, it's mandatory by CNIL. GDPR, it's a data privacy regulation in Europe. It's the equivalent of many other countries, but GDPR, it's quite, let's say, a protective and complex regulation if you compare it to the US. I'm not sure about India being fully transparent, but I assume there is also some specific regulations for data privacy. And the UBO register is one of the ultimate beneficiaries. So let's say that you create your company in France, you have a holding in India, and you also are the only shareholder of your holdings. Then the UBO should be you as the ultimate beneficiary of your company. Moving now to the Dutch BV, we try to follow the same, let's say, structuration. So the corporate structure, it's flexible private companies. The minimum capital is less, but in reality is at least few K euros to be, let's say, considered as a real companies. Managing directors, it also needs to be based within the Netherlands. The notarial deeds required for incorporation, it's something a little bit different. You need to go to a notary in BV, in the Netherlands, sorry, to register your BV, because in fact, you will have to get some official document from the notary. Corporate income tax, as I said before, I will not redo what I explained. It's 19% up to 200,000 euros of profits, and then it moved to 25.8. There is the innovation box regime, 9% on qualifying IP incomes, and there's the withholding tax and dividends. It's 50% standard and 10% with India treaty. What needs really to be keep in mind the exemptions of the participation. So you need to hold minimum 5% of the subsidiaries in the Netherlands, and you need also to get the capital gain. So if you get that with the treaties, it's really a really interesting, let's say, vehicles to do not pay a lot of taxations on your gain of. Innovation box, so effective rate 9%, qualifying IP patents, so you need to register it, and certify your R&D assets. So you need also to validate that your assets you register are clearly linked to research and development. You need to do a lot of specific admin things that will not go further, and larger groups, Nexus approach. So you will have to think about specifics, let's say annual R&D in ML. Holding structure for India. So India's entity, Dutch BV Olco EU subsidiaries, will go there in a minute. So you will see with a more, let's say, diagram how it will works. So the key compliance for Netherlands, you need to register a Chamber of Commerce via notary. So you see that the price for registration for a notary is quite higher versus the French ones, but it's normal linked to the notary's validation certifications. You need also to get some substance anti-treaty shoppings to clearly ensure that your Dutch BV will be managed locally with local managers and managing directors. So just spend 1 minute on this scheme. It's explain you how it will works and what's the preferred dual structures. So you got your Indian parent company in India. You want to create first your Dutch BV Holdco, and this Dutch BV Holdco may hold different type of operational companies. In my example, the best one is to use a French SS as opco, so you can use the French SS to get the tax research credits, the social specific charge, the BSCPs for your employees. And then it will gain some participation exemption between dividends to be paid from your SS opco to your Dutch BV holdco. And with the FEMA compliance equity investment program, you will potentially for sure only be able to pay dividends also between your holdco and your Indian parent companies with very, very low. We said that it's 10% almost of withholding tax. Let's move now to section 2, fundraising structure and instruments. So you will see that the French law offer different rich toolkits for equity and quasi-equity financing, and I will try to give you some specific highlights of each of them, and also link to the tax consequence. So let's say that's typically you will create a company with shares. You have different sort of shares. I said you have the ordinary shares, which are given to the founder of the company. So it's clearly standard seed series rounds. Is it VC typical? Yes, for sure. You have also the BSA, what we call, in fact, it's a subscriptions specific warrants for actions. So that's clearly also something which is standard compared to other countries. We got what we call the BSE Air, which are the safe ones. So that's only a sort of convertible warrant that gives you, in fact, you put some cash within the company and we give you a BSE Air, and this BSE Air should be convertible in actions later on. We got also what we call OCA, which are obligation convertible in actions in French. So it's convertible notes in English, and you have interest bearing and deductible interest for sure. We got what we call BSCP, we already talked about, and we got the preferred shares. So we got some specific one, it's more for equity, which allow you, in fact, to get specific rights based on an ordinary actions. Very briefly, so BSC, bond subscription d'action, warrants to subscribe new shares. So as I said, I will not maybe go further for each type categories. You will get there on the presentations. But what you need to know is that BSC is the typical one. BSC Air, it's more like a simple agreement. So the investor give you, as I explained before, cash, and you will get shares the next round. Clearly not technical security, it's more contractual things. Again, there is a discount between 15 to 25% on the next round valuations. There is potentially a Series A plus to convert things. And what it needs to know is the PSCPE, which are a specific useful, let's say, process in France to give to employee of the company. It's only for employee of the company, a specific incentive to stay there for a certain period of time, because if you held there for at least 3 years, you will get a specific exit taxation. I put in red one comment for you guys, because for Indian founders, if you relocate to France, BSCP must be issued after French tax residency is established. So clearly, you need first to get the French tax residency before emitting and receiving the BSCP. If you do it before, you will have some specific troubles with the taxation. Just a quick update about the rates. So principal taxes in France, it's up to date as of 2026. So the rate has been verified this month. What you need to know, corporate income tax, as I said, 25% standard, 15% on first, 42.5K. All company, there is clearly a minimum OCDE, what we call Pillar 2. And there is also some other specific things for company we have group above 750 millions of euros. Got a flat tax of 31.4%. This flat tax clearly only applied to exiting some capital gains. So, for example, the BSCPE are exiting now at 31.14 for individual shareholder and dividend capitalization. So it's just different from what we call the personal income tax rate in France, which will goes up to more than 45%. So it's an incentive on capital gain versus revenue of your employment. You got also the VAT, which is comparable at GST in many countries. You got 20% rates, and you have specific rates or reverse charge regime. If you need any assistance or if you have any question, keep them for the end, and I will answer it. Revenue as source withholding tax and dividends, 25%. 0.5%, to 15%, sorry, EU parent directives, and 10% with the application of the tax treaty between France and India. And the other one are quite, we already talked about it. There is non-resident IP licensor, interest on royalty directives. So it should be at arm's length principle. So that means in terms of transfer pricing, you cannot do what you want. You need to be at arm's length, which is, let's say, worldwide principle for transfer pricing. Interesting point I just had a few hours ago within this slide deck. It's to give you an overview, very brief, of what are the main differences between, in case of tax audit in France versus Netherlands, because the approach are quite, let's say, opposite directions, and you need to know that it should be some real impact based on the, let's say, selection of the country you will face. So France is more what we call the punitive enforcement logic. So when you got or you have to face on tax audit, and I face a lot of tax auditing in my career, being honest, and each time start like them. The tax inspector coming to your place and just say, okay, they think you are a fraud and that you are doing a lot of fraud within your company. So it's more a punitive approach. They're all thinking that you are hiding things, that you are not paying your taxations. And it's clearly not a business-oriented approach. In the Netherlands, it's more a business and cooperative enforcement logic, which is quite interesting to know. Now it's changing a little bit since the past year, because in fact, Netherlands is also facing a lot of, let's say, really tax aggressive optimization scheme, and now they are trying to give it to deliver it very, very difficultly. So you can also in both countries ask for what we call tax ruling and legal certainty. A ruling, it's that you go to the tax authorities, you ask them a certain question, or you ask them if your comprehension of the legislation is in this way, and then they will answer yes or no, or they will explain why. But after, you will have to apply their final decisions. So if the decision is positive, that's good for you. You know that for few years you will be covered by this decision and no fear to have. If that's not the case, you will have to think about another approach. Tax ruling should be formally, from my point of view, only a request when you have some uncertainty or unclarity about legislation. And again, it should be always submitted by specific professionals, which clearly, potentially, let's say, know the final answer before they will submit it. Spend a few minutes on the R&D tax credits, what we call the CER in French. So CER, it's clearly a real vehicle that it's make a real sense. So many companies and many multinationals create their R&D research in France because there is this specific regime. As I said, it's a tax regime. It's a tax-free credit. So a credit, it's reimbursable in cash in France. So that means that if you don't, or if you cannot offset the credit with any specific tax to be paid because you have only, let's say, expenses, if you don't have sufficient revenue in France, you will be able to get it back in cash, which is a real, let's say, plus versus other countries. What's are eligible? You need to have some salaries. You need to have also salary of employees. or contractors which are, let's say, within the scope of the R&D. So like people having PhD, having making a lot of things. So there is a clear regulation in it. There is a clear, let's say, also control. There is more and more control because many companies, as I explained, come to France to get the credit back or sometimes a cash reimbursement. And then in reality, a few of them are trying to, let's say, optimize a little bit more all the expense they got everywhere, and they try to include expenses which are not really R&D, and that's why it's make a lot of audits and sometimes court cases. In parallel, you got what we call the C2E or Jeune Entreprise Innovante, GEI, and GEI, in fact, it's for a company create less than 8 years ago with 15% or more as R&D expense. And you got a specific 100% social charge exemptions on all your salary. So it's clearly created some really interesting opportunities to hire new, let's say, PhD people, or researcher, engineer in France to get this credit incentive. In the Netherlands, you got what we call the innovation box. So innovation box is more linked about the revenue itself, but you will get a 9% effective corporate income tax on profits. So the difference is, as I said, France versus it's more useful, for credit tax linked to the research credits versus the innovation box for the reduced rate on IP profits. Section 4 now, IP registrations and protections. I think it's, as I explained at the beginning, for me, one of your most valuable assets is your IP. And how it will work, it's really interesting to know within a due diligence what's the VC, what the private equity will look at. And clearly the IP, it's one of the pivots they will look at it, how it's registered, how it's protected, what could be the potential estimation of the revenue generation with the IP. So let's start with how it will be protected within, let's say, Europe or worldwide. Worldwide, you got the what maybe you are already aware of it. It's a copyright, so it's automatic. It's linked to the Berne Conventions, so it's all Berne countries. It's life of the product. It's for more than 70 years of protections, and it's free. So what does it mean in practice? You don't have to pay anything for that. It should be only a software. So clearly it's directly things linked to the software. There is no registrations, and it's a real specific one, which is free, but that's not the most useful when you are coming to Europe. When you are coming to Europe, you got different things to do. So if you come to first one will be, let's say, the unitary patent, the UP. So EPO plus UPCs in June 2023. It will cover in 18 plus states, including France, Germany, Italy, Netherlands. It's a 20 years covering, and it costs you almost between 5 to 8 kilo euros to register your patent. You got only one filling to do all that, and you got 70% cost saving versus a national patent. So it's free specific court also in case of dispute. Now, in reality, I assume you will have to look at also the French patents, what we call brevet in France, which should be registered with the ENPI. So it's only for France. It's 20 years almost, but it's specific cost depending about the type of the brevet you will have. And it's really interesting for what we call the tax research credit eligibility. So in reality, if you don't have this brevet registered in France, it would be really difficult to start getting the tax credit. So the French patent, it's more linked to tax credit. If you want to have tax credit, you need to register with the French patent. You have also the French trademarks, which is linked to, in fact, the your brand directly. It's only for France. It could be interesting, but again, it's more something if you will have to see if you have to protect your trademark or not. The trade secret law is something which is applicable in EU, including France. It's indefinite, it's only contractual, and in fact it protects black box algorithm. It's required active confidentiality measure, NDA, access control. What in fact the interest to mention this there is that there is this specific law within Europe, and this specific directive law allow you to do not have, or let's say do not have the possibility to mention any specific secret or confidential information you will already get from your company or from other companies you are working with. And to conclude, there is also the NL Patent Innovation Box, which is done patent offices for the registrations, and it's only Netherlands. 20 years also in terms of coverage, similar to ENP in France, and it will combine with the Innovation Box certificate needed, and you will need IP developed in another. So in this scenario, you will need to demonstrate that your IP is developed in the Netherlands. What's the IP strategy in case of venture capital due diligence? It's important to note that IP assignment is non-negotiable. What does it mean in practice? So all your IP created by you funders or employees, also contractors, must be assigned in writing. So in practice, that means that if you create your structure in France or in the Netherlands, all your employees need to sign specific working clause saying that all their invention should be directly auto-assigned to your companies. It's clearly creates you a sort of rights to use directly everything and to own all the IP they create. The idea is clearly to then avoid any contestations in case of code that saying, hey, I was your employees, but I create this IP and this IP belongs to me, not to you companies. Interesting point also to note is that for Indian engineers, in fact, if they are working remotely, use IP assignment and NDA governed by French or Dutch law. What does it mean in practice? That means that, in fact, if you work abroad, like in India as an engineer, you need clearly to sign an NDA, and you need also to assign it, like with a clause that which should be similar as the ones that I already talked about within the working contract. There is also some specific audit chain before CRA. So clearly, if you don't have any or if you have any unassigned IP, could be a deal breaker. Trade secret, will not spend a lot of time there. Again, everything should be documented but confidential. So only if you go to code, there is no obligations to share the information with someone external to your companies. Unitary patents. So since June 2023, so almost 3 years ago now, we get a unity patent approach, one EPO filing, which is really good. So that means that now with one EPO filing, you will get 18 states. So it will protect your IP for 18 states within Europe. Can you remember we got 27 states in Europe right now? So it's almost more than 60%, which have been covered. You got an annual referral fees paid centrally. It should be already limit the, let's say, cost. So it should be a cost saving versus national portfolio. But as I explained before, you may need to have different national patents depending of if you need, for example, tax research credit in France, or if you want to create specific IP box in the Netherlands. And to conclude, software patents. So there is no specific patents implemented invention, as I mentioned within the slide. So there is something to need to be discussed in national level in France and in also Netherlands. You need to check what's possible to register, how it truly works. You need also to validate with specific IP experts how you will describe your software, how you will describe your let's say process to be registered, and then you may have also the copyright, which is the first and free worldwide one to be used first. Moving now to section 5, so we talk about different points from the creation of the company till the registration of the IP, structuration, taxation, and everything. And now we are on the last part. So you generate revenue, you have your company, and you want to repatriate your profits from Europe, France, or Netherlands to India. So that's a clear overview of what's going on right now. India, France, and India, Netherlands, DTA. So DTA, it's for the tax treaty between the two countries. So if you have less than 10% participations within the company created in Europe, you will have to pay in France 25%, in Netherlands 15%, and if you got the tax treaty which is applicable, you got 15% in both countries. So the beneficial owner is the Indian resident companies. If you hold more than 10% of the participations, the rate remains the same, but with the tax treaty, you will got 10% in both countries, which is better than the 15 above if you hold less than 10%. In terms of royalty, IP license fee, the French domestic regime is 26.5%. There is no specific regime. In fact, in domestic NL, what does it mean in practice? There is no taxation, in fact, in reality for that. So we see that with the previous one. And with the treaty, it's only 10%. So mainly you would keep in mind that it should be 10% with treaty for dividends and for royalties. It should be 15 only if you get less than 10% participation. The interest intercompany loans that you may create between your Indian entities and the French one to do the financing of the French company or the Netherlands companies, they should be also taxed at 10% with the tax treaties, and the technical service fees, it's only within the French tax treaties and it's 10% too. It's outside the treaty for Netherlands. At the end, the capital gain on shares, 30% domestically. There is not applicable, in fact, in domestic taxation in the Netherlands, and it should be taxed in India in both normally treaties. So an important point I highlight in red is that India and the Netherlands are currently reviewing their tax treaties. It could be some specific cases to keep in mind. So what we will do is clearly have a look with specific dedicated Dutch lawyers to review what's within the scope of the treaties, what's currently in force, what could change within the next couple of, let's say, months, because this should be clearly planned before you do any investment in a dedicated countries. What are the permanent establishment risk? We call it the critical traps. Permanent establishment in France and the Netherlands in practice means that all your worldwide countries will be attributable to it. So let's say that your company is incorporated in India, but you have a permanent risk in France. All your profits generated by your Indian company should be taxed potentially by the authorities in France. So that's why it's really important to keep that in mind. A permanent risk, permanent establishment risk is really, really important things to keep in mind and to be protected for. That's also something which should be clearly scrutinized in terms of fundings. If you already have some legal structure in Europe, I will clearly suggest you to review your positions and to do a quick analysis of if there are any risk. If there are any risk, try to avoid it and try to find, let's say, specific things to reduce the risk or to change it to zero, because if not, in case of fundings and fundraising, you will be really at risk that someone say, hey, yeah, it's too risky, I will not invest any money in your company, because you have a risk that it's maybe a deal breaker from their side. What's a fixed place of permanent establishments? So you have an offices, a factory, a workshop, or a branch. In practice, a regular address in co-working risk if exclusive use. Yes, for sure. You cannot only rent a desk within a co-working and say, yeah, it's my place of business. You need to be incorporated in Netherlands, so it's not clearly created to a peer risk. How it will work, what could be the, let's say, solutions is the use of separate SAS BV entities. So as I explained before, you will have to create your own company. You cannot operate from abroad, from India, direct in Europe with only having someone in a co-working or someone, let's say, in a fixed place of business without having a real legal entity created. An agency PE, it's a person in France or in NL concluding contract for Indian company, like a sort of representative of your company. You send someone in Europe, he come, he sign contract in Europe with companies there, but in fact you don't have still any legal entities running into France or Europe. Then you should create an agency permanent establishment risk. And there is a specific, what we call digital substance test. So the substance test is to check if there is your legal entities you create as a real substance, so a real physical person, a real offices, a real, let's say, activities within Europe. So there is specific regulation for annual substance tests. So you need to have local bank account, you need to have local directors, you need to have local managers, everything. Clearly, they will look at all, let's say, specific clause that will give them an audit trail. So if you have a legal and domestic directors, if you have also an offices, if you have some bank account in France or in Netherlands, everything should be ready to demonstrate that you have your permanent establishments. So you are not running your company directly from abroad, and there is no risk to attract all your revenues there. I put some prevention checklists. So Indian entity has no fixed office in Paris. FRNL employees work for the local entities only and not for the Indian parents. So be ready, careful with creating any employment contract. It should be only with the local entities, not with the Indian entities. All contracts need to be signed by local entities officers. So if you hire a president, if you hire someone, they need to sign the contract, they need to do everything. You don't have to sign it from abroad, like if you are based in India, but you want to supervise everything. You can supervise it, but the signature itself needs to be done with the local officers. You need to be ready for the transfer pricing documentation, as I explained. There is also a minimum substance to get, as explained before. So, just a quick example about dividend repatriations, how it works, step-by-step analysis. So the entity earns taxable profits. You will have to earn it. And let's say in France, as I explained, it's 25% regular one. It's 19% in the Netherlands, followed by 25.8 above 200k euros. After what we call AGM, in fact, it's a shareholder decision assembly, a yearly one. So they resolve the distribution dividends. So to pay these dividends to your shareholders, you need for sure to get a sufficient revenue. So you need to get more revenues at expensive. And you need to wait until the first exercise is finalized. There, the dividend distribution should be also validated, and you will move it directly. There is a specific what we call solvency test by directors in Netherlands. That means that you need to, let's say, demonstrate that your company is solvent from a financial point of view before emitting any dividends payment. After you decide to allocate the dividends to your shareholders. So let's say you are all based in India, shareholder in India, so you will apply specific India treaties, so 10%, for example, in France, and 10% also in Netherlands. And 10% will be what we call the withholding. So let's say we have to pay you 100 euros of dividends. I will withhold 10%, so 10 euros, and I will only pay you 90 euros as payment. So you will receive a net dividend of 90 euros in my examples, and you can claim a company what we call foreign tax credit, FTC, what we paid. Why? Because in reality, we'll have to pay also corporate income tax or specific taxes in India on dividends received, but you will, as you already paid 10%, so 10 euros in my example, in Europe, you may claim also the fact that you will have to use this foreign tax credit to deduce the one to be paid in your own countries. What are the checklist actions I will clearly recommend you to follow before you land in Europe? As I said, you need first to think about the structuration of your company. You need to choose France first and then maybe think in parallel of creating a BV holdco. So you will, if you remember my first example, get let's say two-stage different company combinations, which will allow you to get a lot of IP box usage in the Netherlands, also with specific capital gains exemptions. But in the meantime, you will get in France the crédit d'impôt recherche, so tax credit research, and all the specific, let's say, shares types to incentive your employees. That's something to discuss and align with your local legal advisor or with someone who will take care of it. After it's the registration time, so we'll have to register your company in the country you have selected. You need to register for different for sure taxation also, and keep in mind that there is a notary obligation in the Netherlands, which may potentially delay or postpone if you are within the area the registration of your company. Your IP audits. What does it mean in practice? As I explained, IP is one of your key assets. Then you need to protect it. So it's clearly interesting to work on your IPs, check everything you got, check everything you want to protect, and select the most efficient protecting thing. If that's something you are interested in, I'm working now since a few years with some specific lawyers in France, which are really in charge of that for many companies. So that's something I can also refer to if you need any assistance with that. Now it's time to go to your fundraising, and that's I think the object of the Nice events, which will come first soon for you, all of you. The idea is clearly to know how I will leverage funds and how it will work. So needs to also think about the different potential shares types you can get. So the BSAR, for example, for France, need about the incentive for your employees and check about what should be the best country for me to, let's say, lodge my company versus also the potential funds that you want to target within your fundraising, let's say, process. Tax credit, you start your company, you get everything, you start paying employees, that's being your PhD, your engineers, and now it's time to go to the tax credit in France. Clearly, it's something really important to keep in mind. There is a lot of formality, administrative stuff to follow before getting the tax credit. But that's also something really important to keep in mind because it may have a real positive financial impact in your business case and also within your fundraising. And at the end, the repatriation of, let's say, all your dividends to India, and then you will get the application of the tax credits, of tax treaty, sorry. And as I explained before, tax treaty are quite, let's say, similar between France and Netherlands to give it back. You will also see all the official source, so you will get all the access to it. So I think it's sometimes interesting to look at it, but again, sometimes it's quite complex also. So it's more for your knowledge than for really a unique or standalone usage. I think now it's time for your Q&A sessions. So maybe I will give you the floor.
Sure. Thank you. Thank you so much, Cyril. Great. Especially the last slide, the execution, pointers, that 5, 6 things, we should be very looking at, that is like very apt on point, where it's going to help them. So thank you so much. I would really, like to open the floor for Q&A like we did last time. Please feel free to raise your hands. Yes, Dr. Harsh, over to you, and then we can move forward.
Yeah, thank you so much, Saril. It's a very, very comprehensive and very detailed. So first is we would like to get a copy of this presentation so that we can use it in our expansion plans for Europe. Second, let's say when we open up in Europe, do the representative in Europe who's managing there has to be a shareholder, owner, or just a signing authority is enough?
Thank you, Dr. Ash, for the question. I think it's a good one. You have the both option, let's say. Normally, most of the time, it's better that it should be also a shareholder of the company, so it will have a full link with your company. But in reality, you see that many companies use what we call external directors to represent them. So there is people specifically that are paid for that. And this is a specific job that you will represent the company, and it's mainly for liability approach, because in fact those person will take the full liability of the representation. Because something I don't really let's say list on this session, but I can also add just 1 minute there, is that being a president or legal representative of a company in Europe thinks that you are also liable for the company activities. So what does it mean? That means sometime in France, for example, you could go to jail if you do something illegal. You can do. So again, I don't want to afraid you all or to say it's quite complex, but you raise a good point. And sometimes with the start of a company, you may have a potential quick approach to hire someone external as a director versus having someone really being shareholders domestically based in France or in the Netherlands.
Yeah. Second question is about the double taxation agreement. Even though India has got a double taxation agreement with EU, the individual countries have got a different tax structure, corporate income tax and the individual income tax. So how, like, what do you recommend for that? Because you have given the example of France and Netherlands. In EU, the tax rate could vary a lot. Nordic countries are very, very high, right?
Yeah, correct. In fact, I focus my, let's say, presentation about mainly corporate income taxation. Why? Because most of the time you still own your India-based legal entities, and then you will own the European one like a B2B owning. There is no private individual owning directly on. Sometimes you could be like a private individual based in India and own directly the French or the Dutch BV. In this case, you will get a different capital gain, which will be based on a private one. So there is another analysis to be done, and you need to focus about the personal corporate income tax, which is different from the corporate income tax for companies, for sure.
Yes, thank you. Thank you so much. Thank you. Really appreciate. Great presentation.
Yeah, thank you. My pleasure.
More questions, please feel free to unmute yourself and ask.
Do not also hesitate. I try also to maybe enlarge a little bit the question range, but if you have any question regarding any specificity, I will not say like about French food or something else, but again, if you need someone like a cultural approach also for your speech in France, do not hesitate to raise it. I will be more than happy to support you.
Yeah, I think this is a best platform to ask as much questions as possible before you start your travel and you prepare for yourself. So I think any questions, please let me know. Please raise your hands. Yes, Balu, please.
Okay, thank you so much. I think that was a very useful, Cyril. Now, as a part of the deep tech startup, I'm sorry, I'm not in a position to this one because I'm on the phone, so I'm not able to
Yeah,
switch on my video. My
no
apologies for that.
problem.
I hope that's not rude enough. So, one is as a part of the deep tech startup, one of our objectives is also to engage some of the local researchers um, in the very many campuses and very many research institutes that are out there, be it in France or be it in Netherlands as well. Now, obviously, patent and protection is super important, but we're also trying to apply for some local grants that the local governments kind of extended as a part of the requirement. I mean that we can potentially also apply. Now, in that connection, where we take the local grant, we are that money would be obviously, as I understand, would be given to the local company which has been incorporated inside France or inside Netherlands, and it will never be given to the. You cannot even repatriate or use it for any other function outside the other than possibly funding the research activity. Now, obviously, when we create such kind of a entity inside, and we work with these research students, there is obviously some amount of emerging IP that may come in. That how would that emerging IP be handled in this connection? Because ultimately, the company needs to use that IP predominantly to build on from there on. How will that happen, and what is our obligation with respect to the governments in terms of the grant? So that's my question there.
I will try to, let's say, resume what I understood from your question to be sure I will
Sure.
answer the right one if that's not a problem from your side, Balu.
Yeah.
Clearly, what I understood is that I can confirm that if you have some specific incentive, like the tax research credit or any local incentive to be granted to the local
Mhm.
legal entity in Europe, you need to use those funds to work for the local entities. You cannot say I get a tax credit in France and I use it to pay dividends directly to my Indian company to maybe develop some projects there. You need to use it for the local entities. Now again, all the incentive you may let's say obtain from local government, and there is some incentive, additional ones that I do not mention within those slides, but there is incentive could be granted by the city, by the municipality, by the department, by the region in France or in other countries, and also by European at European level.
Right.
So all those incentives need clearly to be used to develop your local European entities. It cannot be possible to shift them back to India or to other countries. And in terms of your last question regarding the link with the IP,
Yeah.
can you just clarify exactly the question, because
Yeah.
I'm not sure
So
I
what
got it.
happens is, yeah, the money that comes from, let's say, we raise the grant money,
Yeah.
from the local government, and we use that money to fund the research where we recruit students and researchers
Yeah.
locally,
Mhm.
and the IP obviously would belong to, in some sense, the parent and the subsidiary in terms of it's 100% subsidiary. Let's understand.
Yeah. Correct.
Then the IP obviously belongs to shared between the parent and the subsidiary. So how does that work at that point of time? Because this is obviously being funded for the local as well. So can we use that IP, let's say, for globally for other purposes, or are we required to use that IP only because of the fact that we have used the grant money from the local
Yeah.
government? So that clarity is still
Yeah, okay, that's now more clearer. Thank you so much for all the elements. So in reality, what you will get is, as I explained at the beginning, you will start registering your IP in the country where you want. So if you work with, for example, French or Netherlands, and you have all your maybe researchers and PhD located there, you will potentially register your IP in those countries. So as the ultimate beneficiary of the IP should be the Indian legal entities, the holding company. But in reality, what you will have to do is to do a contract between the owner of the IP and the user of the IP. So if you want to use it worldwide, you will have to do an IP, let's say, leasing contract, and then you an IP agreement, and then you will have to generate revenue from France or from Netherlands directly to be paid, by the Indian entities. What I will suggest is to do the opposite way. So try to register your IP, for example, as we have said in the Netherlands, because there is a specific IP box regime which will only be taxed at 9%. And then Netherlands will own your IP and will clearly do the IP revenue generation for worldwide. So you can use it in all countries. Everything should be taxed in the Netherlands with the specific regime. And then you can also get the dividend back to India with the specific tax treaties.
Understood. Okay.
So clearly, it's a good question. The answer is you need to structure it in a way that from a taxation and legal point of view, it's compliant, but also you can do a lot of optimization if you have the right legal structure in place from the beginning.
Yeah. Thank you, Cyril. Thank you so much for that.
Yeah, my pleasure.
Maybe we can take one or two more questions if there are any, like kind of a last stretch, like any final questions, because this is one of the important topics you all have to know before. Any final questions, anyone?
Just maybe one comment, Ananya, from my side. I
Sure.
think at the end, I will also leave you all my details. So if you have any specific questions you want to deep dive, or if you want to, maybe you are now too shy to raise your hand or raise the questions, feel free to drop me a mail, and I will try to answer you as soon as possible. And or at least if I can, if it's too technical questions, I will let you know, and I will potentially redirect you with the right person that can answer it.
Sure, that's like really okay. We have one more question.
Yeah.
Karan, over to you, please.
Yeah, bonjour, monsieur. Comment ça va?
Ah, très bien, merci.
Merci à toi. So, my question is that even if we start a subsidiary in France, which could be a SAS or SARL, we have a company in India, then actually, even if we get a work share budget, we do a work share between the French entity and the Indian entity, there is a concept called transfer pricing.
Yeah, correct.
So how does one plan a structure that it doesn't get dual taxed and the transfer pricing does not erode the profits which can be which can be reinvested back in the company to develop its R&D, market, etc. And
in fact, the transfer pricing, Karan, the generic approach for transfer pricing, it's clearly the transactions between two entities which are, let's say, linked with shareholdings. It's clearly arm's length. What does it mean in practice? It means that's the first approach. You will have to apply the same price for the co-work like if you are doing the same with an external companies. So you cannot reduce it to generate less revenue in a certain state and an extensive revenue in the other one. You need to be arm's length and defendable. So that's clearly the first approach of transfer pricing. After, there is 4 different methods, which we don't have really here time to go through, but that will permit you to have a differentiations based on the type of goods or products or services you are let's say doing. I know that you are talking about share of work. So imagine that you have potentially some employees or consultants working in India, which will also work for the French company, or in the opposite directions. In that way, you will have to build some professional services between your two legal entities, and this should have an impact about the revenue generated in each entities, and it may have an impact at the end about the potential benefits to be split and or to be, let's say, paid by dividends between your company. So transfer pricing is also a point you need to take into consideration into your business case if you want, or if you have to work with, let's say, different type of employees or resources based in both companies.
And my second part to this is that recently EU came up with a new type of structure for starting a new society. But
Yeah.
in France and Netherlands and other European countries, they have their own structure. So is this the common European entity? It
So
is
in
like
fact,
superseding the other ones?
yeah, the new type of structure you are talking about, it's something which has been, let's say, published officially by European Parliament and European Commissions, and it's not yet in force. It should be in force soon, and it should be a very simple company. And again, it will clearly depend about what you want to do. I will not recommend this type of structures, because this type of structures, it's more something very simple to be created when you are a European citizen and when you want to do business within Europe only. In your example, I know that many of you are based in India or abroad and then wants to expand in Europe. So creating this type of structure will not permit you to, let's say, do some fundraising on anyone from the beginning. So it's more something which needs to be explored maybe in the next couple of years after the creation of the legal entities has been clearly finalized. And but as of today, I will not recommend to move this way.
Okay, d'accord. Merci beaucoup, monsieur.
De rien, merci.
Cool. I think any last questions? Okay, just wanted to also remind all of you, we would really, really appreciate your feedback as well. I know it will help both us and Cyril as well to
Yeah,
know,
for sure.
moving forward, we could incorporate this as well in our sessions that we organize, and also for Cyril in his upcoming things that he do as well. So would be really, really helpful if you all could take a minute. It just had like 4 to 5 questions. We would also look at this feedback, also share it with Cyril as well. Yeah, Karan, please go ahead.
Yeah, my request would be if you could also post the recording of this session, and then one can review it deeply and prepare the
Sure, Karan. Yes, Cyril
relevant
has also
questions.
given us
And
the consent to, share it with all of you. So we will be sharing it with Nirupam and Dr. Love. So they will share it with you as soon as possible.
And again, as Ananya said, I'm really interested by getting all your feedback about the, let's say, technical level of the slide deck. If you think it was too technical sometimes, or maybe sometimes not too technical, just let me know, because for me it's also really interesting to get your feedback about the technicity of the presentations. And sometimes I just got the impression it's not too technical, but again, I practice it since now more than 20 years, so it's not something that I can really, let's say, imagine, as you are all, for most of you, let's say, not really a tax friendly persons. It should be really interesting for me to get your feedback.
Yeah. So if there are no questions, I would just want to take last 1 minute, Cyril, before they are all traveling, that one thing that you wanted to tell them before they come to France.
I think first I want that you will all enjoy being in France and maybe discovering the cultures. I don't know if that will be the first time for many of you. I assume yes. So again, I think for me, if I do the opposite direction, or if first time I was going to traveling to India, it was a real shock, cultural shock, but also a real shock in terms of getting or let's say putting some words, some things that I already see on TV or on internet. And for me, what I want to do is that be yourself. Don't try to be someone else. Be yourself. I'm sure you will. You know all each other how to pitch your company, how to pitch your let's say your activities. And again, now what I saw in terms of funding is that many fund wants to focus on clear business case defined. So I think, as I explained in my presentation, I will recommend you to think about the legal structuration of your company in Europe. I think it's better to think now, at least to get in mind what could be the structuration you want. That you will demonstrate to the investors that you are aware of the problems. It's not something that you just leave it away and say, oh yeah, I was not sure about it. It's good to be aware of every blockers, and that's my recommendation.